Bonjour, Madame la Présidente,
Good morning,
Monsieur le Ministre,
Mrs.
chers amis,
Chair,
Mesdames
Mr. Minister,
et
dear
Messieurs.
friends, ladies and gentlemen.
Good morning. It is a real pleasure and an honor to be among you. It is particularly a pleasure to be in this historical room, in this beautiful room with this beautiful painting. I am proud. It is wonderful to see and encouraging to see so many participants gather here from all corners of the world to demonstrate their commitment to the abolition of the death penalty. I am proud to be representing the Council of Europe. On December 2003, I was appointed Council of Europe Goodwill Ambassador for the abolition of the death penalty. The Council has played a leading role as a guardian for our fundamental rights and freedoms in the battle towards abolition, believing that the death penalty has no place in democratic societies. In early 1980, the Council of Europe became a pioneer for the abolition of capital punishment, considering it a grave violation of human rights. The organization's Parliamentary Assembly gradually persuaded government to help Europe become the first region in the world to permanently outlaw the death penalty. In 1982, the Council of Europe adopted Protocol number 6 to the European Convention on Human Rights, which became the first legally binding instrument abolishing the death penalty in peacetime. Europe is today the only region in the world where the death penalty is no longer applied. In 1989, abolition of the death penalty was made a prerequisite of accession for all new member states. Since then, all countries are committed to introducing an immediate moratorium on execution and ratifying Protocol number 6 when joining the organization. As a result, no execution has taken place on the territory of the organization's member states since 1997. To date, the protocol has been ratified by 46 of the Council's 47 states. The one exception is Russia, which has committed itself to ratification and which we hope will finally say that they abolished the death penalty. The idea now is to spread these values to the rest of the world, starting with two countries that enjoy observer status to the organization, the United States and Japan. I will also urge Belarus, the one European country that does retain capital punishment, and all countries throughout the world to follow the European model, outlaw the death penalty and make abolition a universally accepted value. I believe that abolishing capital punishment is a high point among the Council of Europe's achievements. I am very proud to represent an organization that has worked so hard at freeing its territory from state-sanctioned killings. There should be no place for the death penalty in democratic societies. I am shocked and appalled at the unabated pursuit of the application of the death penalty in the US, China, Iran, Pakistan, Saudi Arabia, Iraq, and Japan, among others. The death penalty is a violation of our most fundamental rights, the right to life, a premeditated and cold-blooded killing of a human being by the state, a cruel, inhumane and degrading punishment done in the name of justice. The death penalty is selectively applied. It feeds prejudice against those who are a minority, poor and lacking political clout. The application of the death penalty is unfair, arbitrary and capricious, often based on jurisprudence fraught with racial discrimination and judicial bias. For nearly 3 decades, I have campaigned for justice and human rights throughout the world. In the last few years, I have established the Bianca Jagger Human Rights Foundation. During that period, I have witnessed the state machinery of death at work, selectively killing people because they are poor, a minority, lacking political clout, and cannot afford an adequate legal counsel. The death penalty is unfair and arbitrary, and often based on jurisprudence that should not call itself that name. Clemency should be the historic remedy for preventing miscarriages of justice where judicial process has been exhausted. Regrettably, in many countries, and in particularly one that I know, the system in the US, there is a lack of meaningful appellate review in commutation proceedings. Defendants have poor access to executive clemency, and too often the states fail to recognize the defendant's capacity for change, rehabilitation, and remorse. Those who are executed are rarely those who have committed the worst crime. It is for that I believe that the death penalty is a Russian roulette. It is impossible, as you all know, to ensure that innocent are not executed. Since the reinstatement of the death penalty in 1976, over 130 people have been released from death row for wrongful conviction in the US. They were the fortunate ones that got away before it was too late. But no one knows how many innocent were executed until today. During his first presidential campaign, President George Bush said, I am confident that every person that has been put to death in Texas on my watch has been guilty of the crime charged and had had full access to the court. Well, I am here a witness who witnessed the execution of someone that I and many throughout the world believe to be innocent, Gary Grant, who wanted to be known as Shaka Sankofa. One of the most serious arguments against the death penalty is that human beings and our legal system are infallible. Miscarriages of justice occur far more often than most people realize. When the state executes an innocent person, it is sanctioned murder. These state-sanctioned murders have no place in the 21st century society. Only when it gets its own house in order can America claim to stand for freedom and justice. I am now supporting the case for clemency for Reggie Clemens. He has been on Missouri's death row for over 16 years. He was sentenced to death, convicted of being an accomplice in the death of 2 white women in 1991. Clemens and 2 other African-American men were sentenced to death, while a 4th person, a young white man, was offered a plea deal and is out on parole. The case is like many capital cases, fraught with racial bias. The original suspect, a white man and the cousin of the woman, confessed to the crime after failing a lie detector test and changing his history several times. All 3 black defendants claimed that their confessions were coerced by police beatings or denial of constitutional rights. Reggie and other present on the night of the crime were brutalized by the police. The male cousin of the 2 victims initially confessed to the murders, but ultimately filed suit against the city of St. Louis for police brutality and received a $150,000 settlement. The arraignment judge sent Clemens to the hospital for obvious injuries he did not have before his interview with police. Yet Reggie could not use his own experience of beating at the hands of St. Louis police as a mitigating factor in his trial. The prosecutor behaved so egregiously that he has held in criminal contempt and confined for his conduct. As often happens in capital cases, Reggie's defense team was woefully incompetent and inadequate. The husband and wife team were in the middle of a divorce and conducted themselves unprofessionally. They did not do a pre-trial investigation and had Reggie's mother, who has no legal background, draft questions for the witness. One of the lawyers then moved to California, virtually abandoning the case. Her husband was no better prepared and has since developed a long disciplinary record. African Americans were improperly excluded from the jury. Only 2 of the 12 juries were African Americans, even though, as the judge conceded on the record, in his experience, St. Louis juries were usually half white, half black. There is no physical evidence linking Clemens to the offense. Jurors were improperly excluded from the original trial, and the prosecutor was guilty of serious misconduct. It came to light only recently that critical evidence was never provided to the defense or tested for DNAs.